The Supreme Court gave a landmark ruling on September 23rd, Monday, that downloading, storing and watching child pornography is an offence under the POCSO Act and slammed the Madras High Court, which said that downloading and viewing such content is not punishable. The Apex Court held that the storage of such material without deleting or without reporting the same would indicate an intention to transmit. On January 11th, the Madras High Court had cancelled criminal proceedings against a 28-year-old man from Chennai charged with downloading and viewing child pornography. The High Court had then observed that watching such explicit content in private would not fall within the scope of the POCSO Act. A Supreme Court bench comprising Chief Justice of India D.Y. Chandrachud and Justice J.B. Pardiwala on September 23rd said the Madras High Court committed an egregious error in passing that judgment. The Supreme Court restored the criminal proceedings against the Chennai man and stated that publishing and sharing child pornography content was already an offence apart from creating and downloading such material. It asked the central government to bring in an amendment to replace the word child pornography with child sexually abusive and exploitative material. It also directed other courts not to use the word child pornography in such cases henceforth. The Supreme Court's ruling came after it heard a plea filed by Just Rights for Children Alliance, a coalition of NGOs. The petitioner expressed concerns over the Madras High Court's order and said it might encourage people to watch child pornography under the impression that individuals downloading and storing such content would not face prosecution. The plea stated that the High Court's order would have a negative impact on child welfare. The Madras High Court's order had come in the case in which the 28-year-old Chennai man was charged with downloading child pornography on his mobile phone. The court had quashed the criminal proceedings against the man and said children these days are grappling with the serious issue of watching pornography and society must be mature enough to educate them instead of punishing them. In the present case, a letter received by the Additional Deputy Commissioner of Police Crime against Women and Children led to the registration of case against the accused for downloading child pornographic material on his mobile phone. During the investigation, the mobile phone was seized and a forensic analysis was conducted which confirmed that the mobile phone had 2 files which contained child pornography content involving teen boys. The court took cognizance of the offence under Section 67B of the Information Technology Act 2000 and Section 14(1) of the POCSO Act. The accused had approached the High Court seeking to quash the criminal proceedings. Now let's see what was Madras High Court's reasoning. The Madras High Court's decision was based on several key points. The accused had only downloaded the material for private viewing. It was not published or transmitted, and it was argued that merely downloading and watching child pornography is not an offence under Section 67B of the Information Technology Act 2000. The single bench noted that to attract the offences under the POCSO Act, a child or children must have been used for pornography purposes. In the present case, the court noted that the accused had watched pornography videos but had not used a child or children for pornographic purposes. This, in the opinion of the court, could only be construed as a moral decay on the part of the accused person. However, the Supreme Court order focused on Section 15 of the POCSO Act, which lays down punishment for the storage of pornographic material involving children. What does this section say? Any person who stores any pornographic material involving a child and fails to report or destroy it is punishable with a fine of not less than 5,000 rupees, and repeat offence will be punishable with a fine of not less than 10,000 rupees. If the material is stored for further transmitting or propagating, then along with fine, it is punishable with up to 3 years of imprisonment. for storing child pornographic material for commercial purpose is punishable with 3 to 5 years of imprisonment and in subsequent conviction up to 7 years of imprisonment, the section says. By the way, the Supreme Court is also considering a petition challenging a similar judgment passed by the Kerala High Court as well.